Hello students, this is Professor Manasi Patil from JK Shah classes and I'll be starting up with your CA Foundation Law Revision. As you all know, we have 5 chapters: Indian Contract Act, Sale of Goods Act, Partnership Act, Companies Act and LLP Act. Now from all 5 chapters, the most important chapter is your Indian Contract Act. If you ask me the rough weightage of all 5 chapters, whatever we have analyzed in last 3 exam papers, first chapter, that is your Indian Contract Act, is coming for around 24 marks, 22 to 24 marks. Sale of Goods Act, Partnership Act is coming for around 16 marks each. LLP Act, it's a very small chapter and they'll ask you one question as what we have analyzed, around 5 marks. And your Companies Act around 12 marks, 12 to 13 marks. Of course, as the analysis suggests, the most important chapter is Indian Contract Act, and it is so important because of 3 reasons. First, as you can see, the weightage out of your total marks, 24 marks itself is your Contract Act. Okay, just one thing, whatever weightage I have told you, it is including the options in the paper. So if you add all this up, it will not be equal to 60, it will be more than that. Okay, so why Indian Contract Act is so important? Because first of all, the weightage is so much. Second, Indian Contract Act is again going to come in inter-CA. Of course, it will not be the same, but the rest part, it will be something new, but the base will be the same. And third reason being, Indian Contract Act is again going to serve as a base or foundation for your other chapters. So as you have studied sale of goods, partnership, everywhere, some or the other link is mentioned regarding to your Indian Contract Act. Okay, so with this note, let me start up with your first chapter, your Indian Contract Act. First of all, Act was passed, or first of all, the assent was given by the Britishers on 25th of April 1872. First of all, the Act was introduced on 1st of September 1872, but it was passed on 25th of April 1872. So first the assent was received, that is the approval, and finally it was introduced to public on 1st of September. This everything you know. Secondly, it is applicable to whole of India except Jammu and Kashmir. Thirdly, first of all, or in this case, third point says, what is a contract? It's an agreement which is enforceable by law. An agreement is offer plus acceptance. Of course, there is some complicated definition when it regards to agreement, but it's very simple. You offer, I accept it. We both have agreed to each other's terms. It's an agreement. Contract is an agreement which is enforceable by law. If I give you one simple example, Jay is going to Viru and he is offering him dinner at 8 p.m. Viru is like, fine, I'll come. So this is an offer, this is an acceptance, therefore the whole thing is an agreement. But if he does not go for dinner, he cannot sue him, he cannot take him to the court. So it is not enforceable by law. So it's just an agreement, but it is not a contract. But if I take another example, A is offering house to B and B is going to pay 60 lakhs for this. This is an offer, this is an acceptance, the whole thing is an agreement. Now, B takes the house but does not pay. Can A sue B? Yes. So it's an agreement which can be forced by law. That means it is enforceable by law and hence it's a contract. So contract is an agreement enforceable by law. Agreement is offer plus acceptance. Now, if I take the hierarchy, first there will be offer, then there will be acceptance, which will become an agreement, which is enforceable by law, and hence it will become a contract. From contract, you got the word agreement. From agreement, you got 2 new words, that is offer and acceptance. Let me start up as to what is offer. First of all, in this case, offer, section 2, subsection A. Here, I have divided this in 4 parts, the offer part. First, definition. Second, characteristics. Third, types of offer. And fourth one, it's going to be lapse of offer, that is your offer coming to an end. Now, definition, students ask me, ma'am, are we supposed to remember the definition? Yes. Since it's a law, legal language, you have to remember the definition. You don't have a choice. So definition, it's little complicated, but I will help you recollect this. Characteristics and all are pretty much simple, you can just read it. But definition, before I go on to reading part, I will just explain you in very simple way. A offered his house to B. A wants to sell his house to B, but he cannot simply just stand and smile. If you want to offer something, if you want to say something, or if you want to communicate, you need to speak up or you need to communicate this to the opposite person. So when a person signifies to other person, signifies means communicates to other person, his willingness to do something. What is he willing to do? Sell the house. So he is communicating his willingness to do something or abstain from doing something. See, offer may not be only doing something. Offer can be stopping from doing something also. For example, if I take A tells B, I will give you 20,000, you don't go to New Delhi, any place. So he is offering him for not doing something, but still it's an offer. So when a person signifies to another person his willingness to do something or abstain from doing something in order to get an assent. Assent means approval. When you give an offer, obviously you are expecting acceptance from the opposite person. So in order to get an assent, such an act or abstinence, abstinence is noun form of abstain. Such an act or abstinence is known as offer. One last time, when a person signifies to other person his willingness to do something or abstain from doing something in order to get an assent, such an act or abstinence is known as offer. Characteristics, pretty much simple. It should create some legal relationship. Second one, it should be very specific, certain and not vague. Whatever you offer, it should be very clear to the opposite person. Third one, it should be different from invitation to offer. This point is very important. It should be different from invitation to offer. Now, when I use the term invitation to offer, basically you are not offering, you are inviting. Come and give me offer. For example, I want to sell this antique on auction. It looks like one. If I want to sell this antique on auction, I am giving auction notice in the newspaper. You people read it. You people are interested in buying this. You people come to my auction sale. Just because you come to my auction sale, that does not mean I am selling this to you. You will start bidding 10,000, 20,000, 30,000. And then let's say I like the price of 50,000. So I said 50,001, 50,002, 50,003 sold. What just happened? By giving you auction notice, I gave you invitation to offer. When you came and bid it for 10,000, 20,000, 30,000, basically you gave me an offer. And now when I strike the hammer, I accepted it. So I gave you invitation to offer, you gave me an offer and I accepted the offer. This is, offer should be different from invitation to offer. You want admission in some XYZ college, you buy the prospectus of that college. That does not make you a student of that college. You fill up the application form and now your name comes in the list. So by issuing prospectus, they have first given you invitation to offer. And by applying in the college, you have given an offer. And once the name appears in the list, your offer has been accepted. So invitation to offer leads to offer and offer leads to acceptance. So that's your offer should be different from invitation to offer. Then offer can be express or implied. I might say, I want to sell my house, or I might send you an email. It's expressed in words, it's express. But sometimes I need not speak. For example, a bus stopping at the bus stop. It's an implied offer. He is not yelling his lungs out, come and sit into the bus. It's implied. So it can be express or implied. Offer can also be conditional. I will sell you my house for 50 lakhs if you give me your land. I am putting a condition. So if you want to accept my offer, you better accept it along with the condition. If you say, ma'am, I don't like the condition, then you reject it. But you have to accept conditional offer along with the condition. And lastly, it should not contain a term non-compliance of which would lead to acceptance. Means what? Let's say I tell you I am selling you my house. You have 10 days time. You come and answer me within 10 days. if you don't come and answer within 10 days, normally a person will assume that okay, the opposite person is not interested. But no, I told you something else, that if you don't come to me within 10 days, on 11th day I will treat the offer as accepted. So if I put such a condition and if you don't fulfill the condition, then it would lead to acceptance, which is wrong because I am indirectly forcing you to accept my offer. So offer can be conditional, but it should not be such a condition that if you don't fulfill it, it would lead to acceptance. That's your 7th point. Then next part, types of offer, which is very simple. General offer, general public. Specific offer, special offer, it's made to a specific person or maybe even specific group of persons. Counter offer, cross offer, students get confused here. Counter and cross offers. So first of all, let me talk about counter offer. A offered his house to B for 50 lakhs. B is like, I'm fine with this, but then it's little too much. So therefore, he says, I will buy it, yes, but for 40 lakhs. So when A offered his house for 50 lakhs, he was expecting B will say yes or no. But he did something else which we specialize in, that is bargaining. He did not say yes or no, he threw another offer. This another offer is known as counter offer. Yes, because your offer has been countered by another offer. That's counter offer. Then when it comes to your particularly cross offers, yes, one second. Cross offers, it's, yes, A offered his car to B for 5 lakhs. He posted this letter on 1st Jan, which reached B on 4th Jan. So B will come to know about this on 4th Jan, that A wants to sell his car. But before that, B also posted another letter to A on 2nd Jan, that I want to buy your car for 5 lakhs. And this letter reached A on 5th Jan. That means if you realize, both have offered, but they have exchanged similar offers without the knowledge of another person's offer. So when A offered, he was not knowing about B's offer, and when B offered, he was not knowing about A's offer. So they have crossed each other, but I can't call this as a contract because there is no acceptance here. These are just two cross offers. So this is cross offer. So remember one thing, counter offer always will be one after the other and the offers will be different. But cross offers will happen at the same time and the offers should be identical or similar. And the last type of offer, that is your standing, open or continuing offer. I am giving you an offer that I want to sell my house. Just an example, sell my house for 50 lakhs and the offer is open for 10 days. Out of 10 days, only 2 days have passed. The offer is still open. It is known as open, standing or continuing offer. Then lapse of offer. Lapse of offer, it's very simple. Lapse does not mean cancellation. Lapse means coming to an end. When will your offer come to an end? First, rejection. The opposite person rejected it. I offered you my house, you are like, ma'am, I did not like it, I don't want to buy it. It's lapsed. Second, revocation. Means I only cancel my own offer. I don't want to sell this house anymore, sorry. Third, counter offer. When I offer you something and then you offer me something else, so your offer has defeated my offer. That means my original offer has lapsed. Then lapse of time. I gave you 10 days time. You did not come within 10 days. The offer is over. And then I had put some condition. You did not fulfill the condition. Again, the offer will come to an end. And last one, death or insanity. So if either of us die, offerer or offeree dies or becomes insane before acceptance, the offer comes to an end. One more thing I want to tell you here. If I offer and you accept it and then either of us die, the contract is valid and it will be performed by legal representative. But if either of us die before acceptance, means it was still at the offer stage. The offer has lapsed. So this was about offer. So what did I tell you up till now? Introduction date, applicability, what is a contract, what's an agreement, you got two new words, offer and acceptance. So I told you everything about offer. Let's move ahead to acceptance. It's very simple. Definition, simple words, you tell me. Acceptance means saying yes. So when a person to whom the offer is made, to whom the offer is made, opposite person, signifies his assent as to. Assent means approval. When you communicate your approval to me, it is said that you have accepted it. Then your acceptance should be communicated like your offer. It should be unconditional, because your offer, if your offer is conditional, it's still okay. But if your acceptance is conditional, it will become counter offer. I want to sell you my house for 50 lakhs. You say, yes, I will buy it, but for 40 lakhs. The moment you say this means you have given another offer. So if you want valid acceptance, it should be unconditional. It should be by that specific person only. If I give you an offer, your sister cannot come and accept it. So only you have to accept it. It should be within the specific time which I have given you. It can be express or implied. Either you can speak or you can show me by your actions. And lastly, it should be via prescribed mode. If I tell you whatever your answer, if you are accepting it, please send me an email only. So this is the mode which I have prescribed. So you have to send me your answer via email. So prescribed mode. That's your characteristics. So this is your acceptance. Okay. So we did offer, we did acceptance. Coming to a very important part, and students think this is very confusing. It's actually very simple. See, there was one characteristic which was common in both. Offer should be communicated, acceptance also should be communicated. And you can revocate your offer or acceptance. So once I give you offer, still I can take the offer back. Once you give me the acceptance, still you can take it back. But there is some time limit for this. I am taking one common example for all, 4 points. So first, A and B has to be A and B. Let's keep it simple. On 1st Jan, he posted a letter of offer which reached B on 4th Jan that he wants to sell his car for 5 lakhs. 4th Jan it reached B. He thought for a day or so. 6th Jan he posted his letter of acceptance which reached A on 9th Jan. So 1st Jan A posted, 4th Jan B received it, 6th Jan B posted his acceptance and 9th Jan A received it. Very simple. Communication of offer is complete when? When it comes to the knowledge of the offeree, that is the opposite person. That means it is said to be complete on 4th Jan. Communication of acceptance is complete against offerer, against offeree. Against offerer, A is our offerer, B is our offeree. So normally students say against offerer means 9th, against offeree means 6th, which is wrong. Okay. So communication of offer is said to be complete on 4th Jan. Now communication of acceptance, as I told you, students get confused. They tell me exact opposite. Actually, communication of acceptance is complete as against offerer 6th and as against offeree 9th. Now if you are thinking, ma'am, why are you taking like this? Because if you notice, I have written the word against. As against A 6th, as against B 9th. Now this is a good way to mug up or memorize, but I don't want you to do that. You need to study logically. Logic is very simple. As against A, it is said to be complete when offeree puts the acceptance in a course of transmission and it is beyond his reach to stop it. And the point is beyond your head, I know. It's basically they are telling you communication of acceptance as against offerer is said to be complete when B posts the letter. because once B posts the letter, he cannot stop it. So as against A, it is said to be complete on 6th Jan. And as against B, it is said to be complete when acceptance comes to the knowledge of the offerer. So when does A come to know about the acceptance? 9th. So it is said to be complete as against offeree, 9th. So as against offerer, 6th. As against offeree, 9th. Now this was communication of offer and acceptance. Coming to revocation. So once I give you an offer, law has given me permission that I can take back the offer. But you will be like, ma'am, kuch bhi. To offer hi kyun diya aapne? If you wanted to take it back, why did you give me the offer in the first place? But you know, sometimes last minute changes or something comes up. So law has given me an opportunity that I can take back my offer whenever I want. Whenever, as in, I can take back my offer anytime before you accept it, because once you accept it, it's not an offer, it has become a contract. So I can take my offer back anytime before you accept it. That is, A can cancel his offer anytime before 6th Jan. So revocation of offer is valid before offeree puts the acceptance in a course of transmission. That is, if I write it, it is going to be before 6th Jan, it is said to be valid. As this was your revocation of offer. Just as you are giving a chance to A to cancel his own offer, you need to give a chance to B as well to cancel his own acceptance. So B can cancel his own acceptance anytime before 9th Jan. That means anytime before A comes to know about the acceptance. See, let's keep it simple. I am A, you are B. I offered you, I sent you this on 1st, you got it on 4th. Communication of offer is complete when you come to know, that is 4th. You posted your acceptance on 6th, which I receive on 9th. So communication of acceptance as against offerer is said to be complete when you send it to me, that is 6th. As against offeree, it is said to be complete on 9th when I receive it. I can cancel my offer anytime before you accept it. That means I can cancel my offer anytime before you post the letter of acceptance. Similarly, you can cancel your acceptance anytime before I come to know about the acceptance. I came to know about the acceptance on 9th Jan. So revocation of acceptance is complete or valid before acceptance comes to the knowledge of the offerer, that is before 9th Jan. So as against A, 6th, because A can cancel his offer anytime before 6th, and as against B, 9th, because B can cancel his acceptance anytime before 9th. So always when you get a question, put it in this format, you'll remember. Last time, I will not stretch it further. 4 points. First point, communication of offer is complete on 4th when you come to know about it. Communication of acceptance as against offerer, 6th when you post it. As against offeree, 9th when I receive and read it. Revocation of offer is valid anytime before you accept it, that is before 6th. And revocation of acceptance is valid anytime before I come to know about the acceptance, that is 9th. Coming to your types of contract. See, now normally since we are following Indian law, you have to study types of contract as per Indian law. But as you see the year 1872, you know this act was not made by us, it was made by Britishers. And when Britishers made it, when we got independence, we agreed to adopt it, but we made certain changes. So you as a prospective chartered accountant, your institute wants you to know what are those minute changes between Indian law and English law. So this is the first change. As per our Indian law, we have 12 types of contract. As per English law, they have only 2 types. So if you feel, ma'am, sahi hai yaar, 2 ही type hai, अपना ही 12 types hai. No. If you read it further, you will feel our 12 types are very simple and more sensible, honestly. First, valid contract. Contract which is enforceable by law. I sell you house, you are going to pay me 60 lakh, it's a valid contract. Void contract. Valid contract is something enforceable by law. Void contract is something which is not enforceable by law. Rubbish. Utter nonsense. What did you tell me? Void contract is a contract which is not enforceable by law. So how on earth is it a contract? The definition of contract is an agreement which is enforceable by law. So void contract cannot be a contract which is not enforceable by law. So what is a void contract? It's a contract, means it was valid, but something happened which made it void. I offered you my house, you were supposed to pay me 60 lakh, it's a valid contract. After 5 days, earthquake, ghar nahi rahe. It was valid in the beginning, बाद में void हो गया, it's a void contract, but at least it got a chance to become a contract. Then you have void agreement. Students think that they are same. They use these terms interchangeably, void contract, void agreement. No. Of course, the word void is common, but void agreement is an agreement which is not enforceable by law from the beginning itself. That means it never got a chance to become a contract. It was still an agreement. For example, Jai Viru case, dinner, yes, there was offer, there was acceptance, there was an agreement, but it was never enforceable by law. But at least it was an agreement, so it's a void agreement. Void contract is a contract which is valid in the beginning, subsequently becomes void. Void agreement is an agreement which is void from the beginning. Coming to illegal agreement, means it is forbidden by law, specifically Indian Penal Code. Murder, supari, kidnapping, all are illegal agreements. Unenforceable contracts are those they are not enforceable by law as the name suggests because of some technical defect. This is where students have asked me some doubts. It's very simple. In India, if I want to buy a house, for that I need to go through a legal process. Stamp paper, registration, ye, wo, bahut sara. But let's say, I'm like, kaun ye sab karega? Let's say I'm showing my house to B. He saw the house. He fell in love with the house. He's like, Mansi, I like the house, I'll buy. I'm like, okay, perfect. कल अपना सामान वामान सब लेके आओ और पैसा भी लेके आओ, कल से मेरा घर आपका. He's like, done. He was happy. मैं भी खुश. एक दिन में घर भी बेच दिया. Next day he came with all his saman and money. But now I showed him Thenga, get lost. I don't want to sell this to you. He's angry. Can he sue me? No, because he does not have any proof. Why? Because law tells a very simple thing. When we tell you to follow some procedure, वो आपको follow करना है नहीं. That you don't want to follow. But still, yes, you come to us when things go wrong. Why should we support you? Because you have not followed our procedure. So this contract is technically defective. It cannot be forced by law because you did not follow some process. Such contract is known as unenforceable contract. See, ऐसे तो all other things are perfect, but because of this technical defect, it is unenforceable. Express contract, expressed in words, then implied contract. For example, yes, it's very simple. A was going to supply goods to B's warehouse and B was supposed to pay 1 lakh. But instead of sending it to B's warehouse, by mistake A sent it to C's warehouse. So it was C's duty to return the goods back to A, but C kept it. A can sue C, yes, directly. So even though there is no offer, there is no acceptance, but it's implied that there is an imaginary contract existing. It's an implied contract. Then next, tacit contract. Tacit contract is something which is coming into force by conduct or physical action of a person. For example, if I am the auctioneer, if I strike the hammer, everyone will come to know, okay, it's sold. I don't have to speak, I don't have to yell. It's understood by my action. It's tacit contract. Executed, as the name suggests, past. Executory is future. Unilateral, only one party. Bilateral, both the parties. Coming to your English law. Formal contracts, simple contracts. Formal contracts, contracts of records. Simple judgments of the court. See, for example, if I am the judge announcing the judgment, I will normally write it, if you have seen this in movies, that you are hereby imprisoned for 10 years, so, and then they will sign and put the stamp. This is just a judgment which every citizen has to follow. But according to English law, it's a contract of record. But according to Indian law, it's not a contract. Judge offer थोड़ी दे रहा है, 10 साल चलेगा क्या, वो हाँ बोलता है. So there is no offer acceptance. But according to their law, it's a contract of record. Then contracts under seal, on which you put those seal. They are returned, they are delivered, and you put a seal. They are contracts under seal. And lastly, simple contracts. So if you are wondering what are simple contracts, they have given all other contracts. So as you can see, our law is more sensible. Okay. Now last part of this unit, essential elements, which is very important not only from exam point of view but also other chapters, it will keep coming. What are the essential elements of a valid contract? First of all, offer, acceptance, agreement, enforceable by law, then a contract. So for a valid contract, there should be proper offer, there should be proper acceptance and intention to create a legal relationship. Otherwise, Jai Viru case ho jayega. Second one, there should be capacity of parties. There should be minimum 2 parties. Both the parties should be competent to enter into a contract. You know that there are some parties which are incompetent, minor, unsound minds. तो इनके साथ contract किया तो चलेगा नहीं चलेगा, नहीं चलेगा. So for a valid contract, the parties should be competent. Then there should be free consent and consensus addendum. Free consent means free wish without any force. Yes, more of free consent I will tell you. Consensus addendum means meeting of minds. Both the parties should think about the subject matter in the same sense. Yes, if you think something else, I think something else, it will lead to confusion. I want to sell you my house. I have 2 houses, Mumbai and Bangalore, let's say. So let's say I just offer you the house. You might think she is selling Mumbai house. I might think I am selling Bangalore house. So this is not a valid contract. So for a valid contract, there should be meeting of minds, that is consensus ad idem. Then next, there should be lawful object, purpose should be lawful and consideration should be lawful. What is consideration? Something in return, whatever you receive in a contract is consideration. So lawful object and lawful consideration. Your performance should not be impossible. A tells to B, I'll give you 10,000, get me a star from the sky. This is utter rubbish. So this is not a valid contract. It should not be uncertain. So your particular term should be specific. And it should not be declared as void. So in this case, there are some contracts which are law, which law has already declared this as void. Restraint of marriage, restraint of trade, ऐसे तो all these contracts fulfill all essential elements. फिर भी law ने इनको void declare करके रखा है. So what is all this? It will all come in your unit 3 essential elements. So with this, unit 1 comes to an end. Moving on to your unit 2, that is your consideration. It's a very small unit. I've just put the whole unit in one chart. It will be very easy for you to revise. We'll upload these notes, don't worry. But this should be your last day revision. Yes, because if you notice, we have put this in a very short way. The textbooks, you should be, since foundation is a writing exam for law, you need to read a lot. So there are some students who are very used to very short notes, this notes ki fatafat ho jata hai. You have to remember one thing, that if you read only this much, you will be writing only this much. Human mind, I read so much, I remember this much. In exam I recollect this much. And eventually I end up writing this much. But if I read this much, तो मैं बहुत कम लिखूंगी, फिर marks नहीं मिलेगा. So you have to read the textbooks, the main theory properly. Of course, I'll be telling you what type of questions, how to present, etc., etc. Everything I'll tell you. But this is your revision of your Unit 1 Indian Contract Act. Fine. Unit 2, consideration. Unit 2, consideration. 4 things: definition, characteristics, not types. Doctrine of privity of contract and no consideration, no contract. This is a hotshot question. They've asked it a couple of times, so it's important. And please do not take any unit also for granted, because students ask me, ma'am, Indian Contract Act mein which unit can we leave? None. Because they can ask you question from each unit, or they have kept on, they keep shuffling. So you can't really predict. You can't leave a particular unit just because you don't like it. You have to study everything. First, something in return. Now, for example, if I am selling you house and you are giving me 60 lakhs, what am I getting? 60 lakhs, that's consideration for me. What are you getting? House, that's consideration for you. Whatever we receive, that's consideration. And as you know, consideration is also known as quid pro quo. Yo, something in return in Latin term, nothing else. Now, the huge definition when at the desire of the promisor, promisee or any other person did or abstain from doing something, does or abstains from, it's a huge definition. But you have to remember it. Ma'am, रट्टा मार रहे हैं? Honestly बताओ, possible है? नहीं. Definitions, there is a way to remember it. Always break up the definition in parts. Understand it bit by bit and then mix it all, you will get the definition. For example, same. Let me make it very clear. A offered. See, it has to be A and B. I am not going to take fancy names because my focus is not on the name. My focus is on this content. Yes. So, A is offering the house to B and A is telling, I'll sell you this house for 60 lakhs. कौन घर बेच रहा है? A. कितने में बेच रहा है? 60. Who will decide कि मेरा घर कितने में बिकना चाहिए? A. Because it's his house which he is selling. So A will decide what consideration he should get. What is consideration for A? 60 lakhs. Since offer has been accepted, it is now a promise. So A is the promisor, B is the promisee. So first, this consideration of 60 lakhs has been decided by A. That means it will be at the desire of the promisor. Who will pay this? B. Can his friend pay? Yeah. Can his wife pay? Yes. A will be like, as long as I am getting money, I am okay. So it can be given by promisee or any other person. Okay. B has already paid 60 lakhs in advance. चलेगा? चलेगा. अभी पे कर रहा है. चलेगा? चलेगा. 2 महीने बाद पे करेगा. चलेगा? चलेगा. मतलब it can be either past, present or future. So either he did or he abstained from doing something, that is past, or he does or abstains from doing something, that is present, or he promises to do or abstain from doing something. Such an act or abstinence is known as consideration. Honestly, you have to remember 3 points. It should be at the desire of the promisor. It can be promisee or any other person. It can be past, present or future. So, if you notice, we have finished the definition. When at the desire of the promisor, the promisee or any other person did or abstain from doing or does or abstains from doing or promises to do or abstains from doing something, such an act or abstinence is called consideration for the promise. As simple as that. And 3 points which I told you to remember are our characteristics. It should be at the desire of the promisor, promisee or any other person, past, present, future. Fourth one, it can be negative or positive. This point, students are like, ma'am, how can consideration be negative? What did you say? Did or abstained from doing something. Doing something is consideration, not doing something is also consideration, no? So, not doing something is negative consideration. Chalega. Consideration need not be adequate. मेरा घर 5 करोड़ का है. I can sell that house, just example, huh? I am selling my house worth rupees 5 crores for 5 lakh. कोई बोलेगा क्यों मैम? बस ऐसे ही मूड है, अच्छा मूड है. मेरी मर्जी. That means there is nowhere written that I should sell house worth rupees 5 crores for 5 crores only. I can sell it for 5 lakhs also, 2 lakhs also, even 10 rupees also. मेरी मर्जी. So it can be less than market value, equal to market value, even more than market value. It should be real and not illusory. It should not be imaginary. As I told you, star from the sky, it's imaginary. So it's not possible. It should not be illegal, immoral or opposed to public policy. It can be executed or executory. Either it can be past, present or future. And the last one, consideration for an act which a person is legally bound to perform is not valid consideration. See, for example, if I go to police station and file a complaint, it is the duty of the inspectors to start the investigation. But he tells me, ma'am, I will start the investigation only if you give me 10,000 rupees. I am giving him 10,000 rupees for an act which he is anyways legally supposed to perform. He is already getting paid from government in form of salary for investigation. So if I give him more consideration for an act which he is anyways supposed to perform, it's not a valid consideration. That's your ninth point. Now, doctrine of privity of contract. The word doctrine means rule. The word privity means privacy. Privacy of contract. So, the rule is very simple. When two people enter into a contract, only they can sue each other. Third party cannot come in between and start suing. For example, I sold you the house and you were supposed to pay me 60 lakh. You did not pay me 60 lakh. Can I sue you? Yes. Can my father say, how dare you do like this to my daughter? I will sue you. No, my father can't sue because he is a stranger to our contract. The stranger to contract cannot sue, but if you are a stranger to consideration, you have a right to sue. Means even though you are an outsider, like contract is between us, but if there is an outsider who is getting consideration from our contract, he has a right to sue. Exceptions to the rule, stranger to contract cannot sue. See, normally an outsider cannot sue, but in these 7 exceptions, he has a right to sue. If you are a beneficiary, then you have a right to sue. Means we both are contracting, but benefit is received by someone else. That means he is a beneficiary. He has a right to sue you. Written family settlements. Now, if you want example for this, Karan and Arjun. Let's say they lost their father, mother is pretty old, pretty sick, she is anyways very scared, my husband has passed away, who will take care of me? दोनों भाइयों ने बोला मम्मी हम है ना. मम्मी बोलती है यही तो टेंशन है मेरे को, पता नहीं तुम लोग क्या करोगे, भरोसा नहीं है. बस यही चीज़ बहुत बुरी लगी उनको. What they did is, whatever property they inherited, they wrote on a paper, they told their mother that we, Karan, Arjun, will sell our joint family property and the whole money will be given to our mother. Signed Karan and Arjun. They kept their promise, they sell this property to Mansi and Mansi is going to pay 2 crores. Mansi defaults. Can Karan and Arjun sue? Yes. Can Ma sue? Yes. Because she is the one who is getting benefits, one, and second, there was this written family settlement, she has a right to sue. Third one, in case of partition of HUF, female unmarried member has a right to sue for marriage expenses. 4 brothers, 1 sister, obviously 1 mother, 1 father. Father and these brothers are carrying on HUF, which is going on good. But now they partition because there is some internal problem. So that property will be divided in 5 parts, brothers and the father. But if this sister is unmarried, she can sue them and she can demand marriage expenses. Ma'am, only marriage, not education? Unfortunately, answer is no, not education, because during those days, government used to be very traditional, very old school. So only marriage. Then in assignment, assignee has a right to sue. Assignment means transfer of rights. Example, power of attorney. If I transfer my power of attorney to you, I am assigning my rights to you. So what I can do, you can also do. I am the assigner, you are the assignee. So if I can sue in a contract, you can also sue in a contract, even though you are not a party to the contract. So assignee has a right to sue. Then acknowledgement of debts. Means telling the person, boss, for example, I was supposed to, let's say, I was supposed to repay you 10,000. Fine. I am giving 10,000 to my assistant and I am telling him, please give this to you. So I sent him, I informed you, and then he also informed you, that your money is with me. When can I send you? When can I come and give you? So you are like, come tomorrow. He ran away. He fled with the money. I can sue him? Yes, because employer-employee relationship. Can you sue him? Yes, even though you are a stranger to the contract, but since he acknowledged his debt, means since he informed you, he has a right to sue, you have a right to sue him. Covenants with the land, that is conditions with the land. Sometimes lands are sold or lands are given on lease with a condition. Let's say I give you my land on 99 years old lease with a condition that it can be used only for charitable purpose. So nicely you constructed a hospital for poor people. It's valid, you're fulfilling my condition. But let's say after 10 years I die. आफ्टर आई डाई वैसे भी यू आर नॉट लाइकिंग द फैक्ट कि ये फ्री में हम हॉस्पिटल चला रहे हैं. जैसे कि मैं मर गई, आपने वहाँ पे मॉल बना दिया, यू डिमोलिश द हॉस्पिटल. Now you are not fulfilling or respecting my condition, so I have my children, my legal representative can sue you, even though they were not a party to contract. If contracts, and last one is agents and principal. If I am the principal, you are the agent, you contract with my customers. And if customers are doing some mistake, you can sue the customers, even I can sue the customers, because you are eventually doing this on my behalf. This is your doctrine of privity of contracts. And the last part of this unit, no consideration, no contract. So for a valid contract, there has to be consideration. Even if the consideration is less, it's okay. Yes, if it's less, it's okay. If it's equal to market value, still it's okay. More than market value, still it's okay. But zero is not okay. Exceptions, first one, love and affection. Now, it's not only love and affection. It is written and registered agreements arising out of natural love and affection. Now, for example, let's say A is giving a loan to B and B was supposed to repay, but due to some reason he is not being able to repay. So A is telling him, if you don't pay now, I'll sue you and all. So B is scared. B का बड़ा भाई C आता है. So his elder brother tells A, you don't worry, I am giving this in writing to you that if my brother does not pay, I will pay that. So he is giving this in writing to A. So he promises to repay. But A is not giving him any loan. First A went to B, B defaults. Now A went to C, C also defaults. दोनों भाई एक जैसे. So now in this case, can A sue C? Yes, because it was written, registered and arising out of natural love and affection which is there between both the brothers. Second, compensation for past voluntary services. In past, let's say for example, I am saving a drowning girl. I don't know who that girl was. वो लड़की डूब रही थी, मैंने कूद के उसकी जान बचा ली. And somehow the parents, after some few weeks, the parents found me because I am telling the girl, I am asking the girl where does she stay, etc., etc. She told me, मैं उसको घर तक छोड़ के आई, उसके बाद मैं आ गई. Then parents were looking for me. So after few weeks, parents told me that we want to give you 10 lakhs for your heroic deed. I'm like, इसकी क्या ज़रूरत है? But आप बोल रहे हो तो मैं ले लेती हूँ. So I decided कि कब पैसा आएगा, which account, etc., etc. Okay. Now what happens is they don't pay me. Can I sue? Yes, because it was payment for my past voluntary services. Of course, I'll have to prove in the court that they promised. How? That is lawyer's problem. None of our business. But I can sue. Then if there is time barred debt, a debt which has become time barred because of 3 years, means it has expired, normally you cannot sue the person. But if he gives you in writing that he will pay and still if he does not pay, you can sue. Agency, if there is agency, principal agent, even if there is no consideration, it's still treated as okay. So if you ask me, many students have asked me, ma'am commission नहीं है तो क्यों काम करेंगे? अरे दोस्ती यारी में मदद करने के लिए काम कर रहे हैं. कंसिडरेशन होगा तो भी चलेगा, नहीं होगा तो भी चलेगा. Bailment, that is when you deliver goods for a particular purpose. Once your purpose is over, yes, the goods are to be returned back. It's still going to be valid. So in bailment, even if there is consideration, okay. Even if there is no consideration, still it's okay. And charity, dan dharam mein you don't get anything apart from dua, but still it is going to be considered as valid. So with this, Unit 2 consideration comes to an end. Unit 3, your favorite unit. If you see the heading, essential elements of a valid contract. So in unit 1, what we saw essential elements, this one we saw offer acceptance. But all other things we will be seeing in depth in your unit 3. First one, there should be capacity of parties, they should be legally competent. Now there are some people who are incompetent. First one, minor. He is a person whose age is below 18 or less than or equal to 18. It has to be below 18. The moment 18th birthday aa gaya, obviously you become a major. So if you enter into an agreement with a minor, it's void ab initio, void from the beginning. And parents or guardians are not responsible for his contracts. Parents will say, आपको किसने बोला था इसके साथ contract करने के लिए? You do it at your own risk. So parents are not responsible. हाँ, but they can enter into a contract on behalf of minors, but for their benefits. So many people are minors, but still they have their bank accounts. But they don't enter into a contract with the bank, parents do it on their behalf. So in this particular case, yes, parents or guardians can enter into a contract on behalf of minor, but for their benefits. But they cannot buy or sell any immovable asset, land, building, flats, etc. Law बोलता है, parents, if you want to buy a house, you do it in your own name, not in your child's name. Then, if minor falsely represents his age, the contract is void ab initio as he can always plead minority. Let's say there is one boy जो है 17 का, दिखता है 19 का, बोलता भी है 19. So, if anyone contracts with him thinking that he is a major, still the contract is void ab initio because he is falsely representing his age. He is falsely telling everyone his age. Still it's void ab initio because he can always plead minority. Means वो हमेशा ये बोल के बच सकता है कि sorry, I am still a minor. Minor cannot ratify the contract after attaining majority. So in this particular case, you cannot approve something. So let's say Mr. A is 17 years. He takes a loan from me and he tells me, ma'am, even though I'm a minor now, I'm taking loan and after my 18th birthday, I'll approve this contract, make it valid. That's not possible because when the contract happened, it is void ab initio. Next, if any necessaries of life are supplied to a minor, means food, clothing, shelter, education, health is given to a minor, he is not personally liable, but his property is liable. So if anyone, when I talk, not only guardians, it can be anyone. For example, the grocery wala is selling him food items. That means it still comes in the category of necessaries. He can claim it from his property. So if any food, clothing, shelter, education, health are supplied, he is not personally liable, but only his assets are liable. You can appoint a bachcha, that is your minor, as your agent, but he is not liable for any losses. So you do it at your own risk. Second point, pretty weird, unsound mind. Simple words में पागल, but ऐसा नहीं बोलेंगे हम. इसमें भी definition है. Person of unsound mind is a person who is not capable of understanding the terms of contract and forming a rational judgment. जिसको नहीं समझा, पागल. वो पागल नहीं, इसका मतलब पागल. Unsound mind. Now, unsound mindedness, strangely, is of two types. Permanent. बेटा तेरा कुछ नहीं हो सकता. Legally, you are defined as an idiot. And if anyone enters into a contract with an idiot, he is an idiot because it's void. If it's temporary, ये सही है. कभी कभी sound, कभी कभी unsound. ऐसे तो ठिकाने पे है, कभी कभी बस उड़ जाता है. So if a contract is entered during lucid intervals, lucid means sound, it's valid. But lunatic means unsound, it is void. Students tell me, ma'am, ये सब तो ठीक है, but how will you come to know at that time whether he is a sound mind or unsound mind? Yeah, that you will have to prove. Ma'am, how to prove? It's not there in CA syllabus. Because we chartered accountants don't have to prove, we just have to know the laws. So how to prove is none of our business. And third, who are incompetent is disqualified by law. So they are majors, they are of sound mind, at least लगता तो है, फिर भी law ने disqualify करके रखा हुआ है, नहीं कर सकते. First one, alien enemies. Alien means a foreigner. Enemy means a foreigner of that country which is at war. Whatever comes to your mind, control your emotions, I can't say that. But see, foreigner can be, in this case, alien friend or alien enemy. Alien friend matlab there is no war. You can enter into a contract with an alien friend, but automatically once the war is declared, he becomes an alien enemy, so now the contract becomes void. Insolvents, bankrupts, you can't. Convicts, people who are convicted by the court, people who have been guilty and they have been announced guilty by the court. Foreign sovereigns, diplomatic staff, representatives of foreign state, all these big people. For example, any president of any other country comes to India, you cannot directly go and contract with him because he enjoys certain protections. So, yes, he is disqualified by law. Last one, corporation and a company. Every company and a corporation has been given some limit. So, there is memorandum of association for a company, and for corporation they have their own laws. So, a company and corporation can act only within their powers. If they go outside their powers, those contracts are void. Within powers, the contracts are perfectly valid. Consensus addendum. As I told you, meeting of minds. Now, free consent, I've just tried to put the whole thing in one chart. Free consent, we saw consensus addendum. Free consent, consent is said to be free if it is not induced, means obtained by coercion, undue influence, fraud, misrepresentation, and then you have mistake. Let's talk about coercion. It's very simple. Dhamki, threatening someone. If you don't sell me a house for 5 lakhs, I will kill you or I will kill your wife. This is coercion because you are committing or you are threatening to commit something which is forbidden by IPC. Physical force is involved because someone is threatening you to kill or something which is forbidden by IPC. Acts are forbidden by IPC. This point, no relationship, I will tell you. Before I go on to next points of coercion, I would like to tell you about undue influence. Undue means unfair. Influence means you are controlling someone. Undue influence means you are trying to control someone by taking unfair advantage. For example, let's say doctor and a patient. Normally, doctors, whatever they say, patients believe because we have trust. So, there is a fiduciary relationship. We cannot question. Of course, there are some patients who Google it also. Okay, let's see whatever this doctor is saying is right or wrong. But normal human beings normally trust the doctor, they trust the teachers, they trust chartered accountants, they trust the lawyers, etc., etc. So, there is some trust element involved. So, doctor is telling the patient that you have cancer at a preliminary stage, but the patient is very rich and he is very scared. So, doctor tells him, don't worry, I will cure it by those chemotherapy sessions, but it's a little expensive. So, he charges him 20 lakhs. Actually, chemotherapy sessions normally the doctor charges is 2-3 lakhs, but he charges 20 lakhs to that patient. But he will not think much. He will think of, okay, my life will be saved. And doctor is saying something, that means there has to be something. So, doctor is influencing the patient for taking undue advantage of 18 lakhs. This is undue influence. So, there is no threatening, but mentally you control someone. So, there is mental force involved. But these acts are not forbidden by IPC. See, whatever doctor has done, I agree it's wrong, but that does not make him a criminal. There are so many doctors who charge 100 rupees, 500 rupees. Some doctors charge 10,000 for 5 minutes. That does not make them criminal. But for influencing someone, you need to have a relationship. Doctor, patient, CA, client, teacher, student, parents, children, so many. So, in this case, fiduciary relationship is required. Only then you can influence. But coercion, no relationship is required. Dhamki dene ke liye, threatening someone, why do you need a relationship? Just go and threaten that person. I mean, that's what is written. Then, Suicide amounts to coercion. So normally students tell me, ma'am, suicide is emotional blackmail. If you don't give me this, I'll go and suicide. So this is emotional blackmail. I agree, but still it will come in the category of coercion because suicide is crime. Threatening to commit suicide is crime. So it comes in the definition of coercion. So suicide amounts to coercion. And since in coercion you don't require any relationship, coercion can happen by third party on third party also. For example, A and B. A is telling B, if you don't sell me your house for 5 lakhs, the house is actually worth 5 crores, huh? A is telling me, if you don't sell me your house for 5 lakhs, I will kill you. This is what is happening between A and B, okay. Now let me change this. A's elder brother C comes and he goes to Chotu B, B's son, and he tells him, tell your father to sell his house to my brother for 5 lakhs, otherwise I will kill you. That means actual contract is taking place between A and B, but coercion is happening by C to Chotu B. So this third party on third party is possible in coercion, but this is not possible in undue influence because relationship is required in undue influence. Coercion, undue influence, they are avoidable at the option of the aggrieved party. See, this one type of contract I had left when I was teaching you unit 1 and I had told you it will come again. मैंने बोला था ये आएगा. देखो ये आ गया. Now, see, what is this? Students get confused in void and voidable. Let me just take up this example only. A threatened B that if you don't sell me your house for 5 lakhs, I'll kill you. Poor B got scared and he ended up selling the house for 5 lakhs. Is B's consent free? No. So can I call this contract valid? No, because it is not fulfilling the essential elements. So I have to call this void. But if I call it a void, it will become not enforceable by law. So in this case, B will not be able to sue A, but this is wrong because something wrong has happened with B, so B should be able to sue A, na? So I can't call it valid, and if I call it void, it will become not enforceable by law. Therefore, government introduced voidable, neither valid nor void, somewhere in between. So voidable, the aggrieved party, that is the weak party, has two choices. Either he can rescind the contract, that is cancel the contract, or he can affirm the contract, that is continue the contract. So B can cancel the contract, get the house back, things will become normal, or he can continue the contract and continue selling the house for 5 lakhs. It's his choice, but only the weak party gets an option. So it's voidable at the option of the party whose consent was caused. So aggrieved party can either rescind or affirm the contract. Always remember, when you see a situation where one party is suffering and another one is making him suffer, 99% cases it's going to be voidable. And if you think this contract is voidable, ask yourself one question: who is the aggrieved party? If you don't find any aggrieved party, then it is definitely not voidable. So coercion and undue influence. Coming to your fraud. Favorite section? Normally people say favorite section of CS. It has got nothing to do with CS. We have just got good better brains. Anyways, fraud, cheating. Students tell me dhoka, whatever, cheating. But I will tell you this in a legal way. Intentional misrepresentation of facts. Now the word representation means statement. Misrepresentation means wrong statement. Intentional misrepresentation means deliberately you have made a wrong statement. This is definitely going to be fraud. So for example, prospectus of a company, X Limited. Director has made a statement. Mr. Mukesh Ambani is the managing director of the company. Actually, he is not the managing director, he is just writing it, and signed Director D. So he knows that if people read this, they might end up buying more shares because Mukesh Ambani has a very good goodwill. So intentionally made a wrong statement. This is fraud. Let me change this. Director made the statement in the prospectus, but he himself thought that Mukesh Ambani actually is a managing director and therefore he made the statement. Whereas the reality is he is not the managing director. So here director made a wrong statement, intentionally or unintentionally? Unintentionally. So this is not fraud, this comes in misrepresentation. Unintentional misrepresentation of facts. See, here also you are making a false statement, here also you are making a false statement. Here you are doing it deliberately, here you are doing it unintentionally. Then you are concealing some facts or defects, that is hiding. You are making some promise without any intention to perform, that you might have done since childhood. Then there is an intention to cheat, therefore it is forbidden by IPC. People say 420, 420, 420. It's actually a section of fraud of IPC. That's the reason people who do fraud are known as 420. You might be knowing this. Then, in this case, since here innocently you make this, I'm talking about misrepresentation now. Since you make this innocently, it is not forbidden by IPC. But here in fraud, it is forbidden by IPC. In fraud, the person who makes the statement, he knows that his own statement is wrong because he has done this purposely. So the person making the statement does not believe it as true because he knows he is lying. But in case of your misrepresentation, he believes it to be true. Then, very important part, mere silence does not amount to fraud, but when silence is equivalent to speech or when there is a duty to speak and if you don't speak, it will be fraud. For example, I am offering you horse. I tell you, my horse is there, you go and have a look, you like the horse, you buy it. Now, ghoda, in this case, langda hai. The horse is handicapped. You can see this till you buy the horse. After 2 days you come to me and tell me, ma'am, you have done fraud with me. आपने बोला क्यों नहीं कि घोड़ा लंगड़ा है? मैंने आपको बुलाया, इधर आओ, इधर आओ. क्या हुआ? बोलता है मैम घोड़ा लंगड़ा है. मैंने बोला देखो घोड़ा तो लंगड़ा है, आप भी अंधे हो क्या? You can see this. You can't treat my silence as fraud here because you could have seen this. But let me change this. This horse is suffering from some kind of internal disease which cannot be seen. ऐसे दिखने में fit and fine है, but internally some disease. Now, if I conceal this disease and if I don't tell you about it, then it will be fraud because here it was my duty to speak and still I did not speak. Then it will become fraud. Even fraud is going to be voidable at the option of the aggrieved party and he can also claim damages because there is cheating. Misrepresentation is also voidable. But aggrieved party cannot claim damages because there is no cheating. So I told you coercion, undue influence, fraud, misrepresentation. Now coming to your mistake. Mistake is of two types. Some people say, ma'am, गलती में भी 2 types होते हैं. हाँ है, law में ऐसा ही है. Either you make a mistake of law or you make a mistake of fact. Mistake of law. Forget about fact as of now. Mistake of law, either you make a mistake of Indian law or you make a mistake of foreign law. Hey, you being an Indian citizen, if you make a mistake of Indian law, chalega nahi chalega? Obviously nahi chalega. So it's excusable or not excusable? Not excusable. So it's valid or void? Normally students tell me void. But guess what? It is valid. मैम ऐसे कैसे, ये डाउट है हमको. So I'll emphasize on all these important points where students have doubts. So for example, A joined a company X Limited. Okay, he's working for the company and X Limited is giving him salary of 50,000 a month. Let's say as per Income Tax Act, tax to be deducted is 10% TDS. Just example, okay. So every month in his hand he should get 45,000. 5,000 will go to government. But in Income Tax Act there are so many percentages now that the company got confused. Instead of deducting 10%, company ended up deducting 5%. Means company made a mistake of law, Indian law, that is Income Tax Act. Chalega nahi chalega? Nahi chalega. So, according to your old answer, it is void. If I assume it's void. Company realized, yaar, we made a mistake. So, company called A. Hey, come here. Sorry. We made a mistake. Instead of deducting 5%, instead of deducting 10%, we deducted 5%. So, as per the students and everyone, mistake of Indian law is not excusable, so void hai. So, from tomorrow onwards, don't come for work. And tomorrow onwards, you will not get your salary also. A is like, what just happened? And why it just happened? So, in this case, can A sue the company? You will say yes, but I will say no. You only told me it's void. It's not enforceable by law. So, how can you sue? But ma'am, galat hua hai. Exactly my point. Galat to hua hai. So, I can't call it void. But it has to be perfectly valid. Because law says, when I say mistake, be careful with my words here. When I say mistake of Indian law is not excusable, means such a mistake cannot be given as an excuse for not performing the contract. That means the contract should be performed by rectifying the mistake and hence it is valid. एक तो you make a mistake, एक तो गलती करते हो, second उस गलती को बहाने के तौर पे देते हो कॉन्ट्रैक्ट को परफॉर्म नहीं करने के लिए, which is absolutely wrong. So you cannot give that mistake as an excuse for not performing the contract. So you better rectify the mistake and start performing. So in this given situation, next month onwards, the company will deduct more tax. And whatever tax all these months they have not deducted, they will deduct more tax, they will pay penalty and interest to government. Government bhi khush, company bhi khush, aap bhi khush, be happy. So it's not excusable, means it's perfectly valid. You know why you students think it is void? Because you see a negative word and therefore your mind says it's void, which is wrong. So when I say it is not excusable, means you better perform the contract, it's perfectly valid. Okay? Yes. Then mistake of foreign law. If you are making a mistake of foreign law, so Indian law says, Indian law याद रखो बस है, foreign law बहुत सारे हैं, no need to remember. See, even if you make a mistake, it's excusable, you cannot rectify it, the contract becomes void. Then, mistake is of fact. What do you mean by the word fact? Fact means truth. Truth is you people are sitting and studying there. Oh wait, that's an assumption. No, it's the truth. Fine. The fact is you people are studying. So if you make a mistake of fact, let's talk about unilateral mistake first. It's valid. Mansi goes to a jeweler and tells the jeweler, give me 18 karat gold. Jeweler gives me 18 karat gold and I pay 20,000 for this gold. Tell me, contract chalega nahi chalega? Chalega. It's perfectly valid. But in this situation, what happens is, it's perfectly valid. Mansi ko lagta hai, Mansi thinks 18 karat gold is pure gold, which is rubbish. This is just an example. Don't take it seriously. So Mansi thinks 18 karat gold is pure gold, which is wrong. The fact is 24 karat gold is pure gold. So Mansi made a mistake of fact, which is unilateral mistake. She comes back to the jeweler and tells the jeweler, you have done fraud with me. Jeweler is like, madam, you asked me for 18 karat, I give you 18 karat. How will I know what is going on in your mind? So it's your mistake, you better suffer. Why should I suffer? So aapki galti hai, you suffer, it's perfectly valid. But when I say bilateral mistake, दोनों की गलती है, तो बेटा कुछ नहीं हो सकता. For example, if I take, in this case, on 5th of May, A and B contracted that A is going to deliver some mangoes to B via ship. And B is going to pay 20,000 for these mangoes. 2nd May ko, the ship is already sunk. Both of them are not aware, A and B are not aware about it. So they think that the ship is there. but actually ship is not there. So both of them enter into a contract by mistake. It's bilateral mistake, you can't perform, it's void. If someone is thinking, ma'am, they can deliver some other mangoes, then that will become a new contract, but this contract becomes void. So mistake is of fact, bilateral mistake is void, unilateral mistake is valid. But you know, I said bilateral mistake, it is void, but there is one exception to this. If the bilateral mistake is regarding price of goods, it's going to be perfectly valid. Now for example, if I say, I and Mr. X contract that I will supply some materials to him for 10,000 rupees. We thought the market value of the material is 10,000 rupees. But actually the market value is 30,000. But we thought it is 10,000. So we contracted at 10,000. Chalega nahi chalega? Chalega. Our wish. Because you studied one point, consideration can be inadequate. So if we both are okay with the price of 10,000, to chalega. Normally bilateral mistake is void, but this is one exception. So this is mistake. So what have I told you up till now? We finished unit 1, contract, agreement, offer, everything about offer, that is your definition, characteristics, types and lapse. Then we saw acceptance, definition and characteristics. Then communication of offer acceptance, which is very simple, 1, 4, 6, 9, the dates. Communication of offer, 4th. Communication of acceptance as against offerer, 6th. As against offeree, 9th. Types of contract, essential elements, out of which we finished capacity and free consent, consensus addendum. This is pending. Consideration we saw, definition, characteristics, doctrine of privity, and no consideration, no contract. Other essentials, competent parties, some are incompetent, minor, unsound mind, disqualified by law, yes. Then I told you what is consensus ad idem, what is free consent, coercion, undue influence, fraud, misrepresentation and mistake.